day. And I want to start off by saying how proud I am of the group that we've assembled together. Essentially, we are 4 different lawyers from 4 different disciplines, all respected in our different fields, and all have information to share that's particularly pertinent to this COVID-19 coronavirus world that we're living in. And because no lawyer knows everything about the law, we are providing you our collective knowledge within our respective disciplines. So as the moderator, I'm going to go first, and then I'm going to introduce our other speakers. But very, very quickly, we have on the call today, Dan Sarfati with Sarfati Corporate Legal. We have Danny Lavin with Lavin Law Group, and we have Jarrett Williams with the Law Office of Jarrett Williams. They'll be talking about corporate and business issues, real estate issues, landlord-tenant issues, and all these sort of things that are on people's mind. Jason Neufeld, I'm an elder law attorney with Elder Needs Law, and I focus mostly on Medicaid planning and estate planning. And these are very important issues today. Real quickly, if you don't know what Medicaid planning is, what I do is I work with people who are 65 years old or older, or are younger and disabled, so either of those categories. And if you are in one of those categories, I can legally and ethically protect your income and assets and get the government to pay for your medical costs, your prescription costs, puts a little extra cash in your pocket every month, home health care, assisted living facility care, and nursing home care. So these are really long-term care issues that we're dealing with. And the most prominent question I'm getting in the Medicaid planning world is, will home health care agencies still come to my house in this world of everyone being quarantined? And the answer is yes. I was on the phone not 2 days ago with my good friend Linda Bargnanzini from Home Caring Group, and they are equipping their home aides with the masks and the gloves, and they're doing the best they can because, quite frankly, not everyone has the option to be self-quarantined. There are people who can't get out of bed without the help of somebody else. So again, we're not living in an ideal world, but we're doing the best with what we have to work with. But more frequently, I'm getting questions on the estate planning side of my business, which is who's going to make medical decisions for me if I'm unable to make those decisions myself, and who is going to get my assets should the worst happen. And a corollary to that is I've done that planning, but I did it such a long time ago that my beneficiaries have changed and my important decision makers may not be who I originally wanted them to be. And what do we do about that? And there's a lot of, the good news is there's a lot of options out there in terms of what we can do even in this quarantined world. And then there are some other solutions that are will take some time to get to, and I'll explain what I mean in a second. So there's a lot of attention that's being brought to the fact that remote online notarization has become legal as of January 1st, 2020. So some people call that electronic notarization, some people call it online notarization, but the law refers to it as remote online notarization. And the fact is that there are certain documents that can be remotely witnessed and notarized right now, or as of January 1st, and there are some documents that cannot be notarized until July 1st, 2020. So let's start with what can be remote online notarized. And when I say online notarized, what I mean is you can be sitting in your house by yourself with nobody else around you, and we have the capability to have certain documents witnessed and notarized by people who are elsewhere. Okay, so this is very important, especially in a world where people are self-quarantining and they're thinking to themselves, how am I going to get these important documents done? So the first major estate planning tool that we have at our disposal pertains to real estate. And for, quite frankly, for most Floridians, their real estate is the single most...
And put your chin up. It's going to go deep. It's uncomfortable. It doesn't hurt, okay? It's in your nose.
Thank you.
So you put your chin up.
Hold on.
Opening him up.
Yeah. Mute. I'm going to do mute all. Let's see. Mute all. Here we go. Hey, guys, can I get a thumbs up if you can hear me? Terrific. I'm going to unmute you as I go along. If I forget to do that, like do one of these so it brings it to my attention. Okay. So for most Floridians, their deed is going to be, their real estate is going to be the most significant asset that they own. They want to make sure that goes to the people who they choose And with the tool we have to deal with that is commonly referred to as a Ladybird Deed. All deeds, including a Ladybird Deed, can be remote, online, notarized right now. We don't have to wait until July to do that. So what that means is, in a Ladybird Deed situation, a firm like ours is drafting the deed, and we're basically saying, I, the property owner, deed this property to myself to do with whatever I want for the rest of my life. And if I still own that property upon my passing, here's who I want it to go to. Okay, and that is recorded in the public record. And when the property owner passes away, without having to open a probate, almost like magic, it goes directly to the folks who are listed in that deed. Now, is that a perfect solution? It's not a perfect solution, because what happens if one of those folks happen to predecease the property owner? What if one of those folks is special needs, or they have a gambling problem? You want them to benefit from it, but you don't want them to get it directly. And in that situation, we would prefer to utilize a revocable trust, but a revocable trust is not as easy to get signed in a quarantine, socially distancing world. And so we may want to start off with a Ladybird Deed, and then come July, or whenever this virus calms down, we can do something that's a little more comprehensive. So we're effectively, if everything goes as planned, the Ladybird Deed will be fine. If not, it certainly is not a perfect solution. It may surprise a lot of people to hear that not every most estate planning documents, in fact, don't require notarizations at all. One of the most common documents is, in fact, a will. A lot of people think that the will has to be notarized, and it, in fact, does not. Not only that, but the statute says that any two competent adults can be the witness, even if they're interested parties, which means if you live with your spouse and an adult child, you have enough people to sign that will. We can draft a document, email to you, you have it printed, you sign it in front of the two witnesses, and you are good to go with that will. Again, is that a perfect solution? It's not, because when you have the only interested parties being the witness, you open up the will to being contested or challenged. And that, of course, is not ideal, but we're going to do whatever we can now. The part of a will that is frequently notarized is actually an optional section that's referred to as a self-proving affidavit. And all that does is that is in fact notarized, and that prevents the witnesses from having to be called into court to verify that they actually saw the will being signed. So again, we can get a will, perfectly valid, perfectly legal will, done right now, and then do the self-proving affidavit come July, or again, whenever the virus calms down. The other issue is folks are very concerned about who is going to be making their medical decisions for them. A healthcare surrogate designation and a living will are two other documents that also do not require notarizations. We often do it because it's best practice, but it's not legally required. And for a healthcare surrogate to be valid, and by the way, I'm giving away those documents for free. So if people want to reach out to me, there's no catch. You don't have to buy anything from me. And Dan is doing that as well. Exactly right. And we're coordinating an effort with the Broward County Legal Aid to help anyone in Florida in need. But for your own documents, I can email you these documents, give you the ability to explain to you how to get it signed. The only difference between the healthcare surrogate and the will is the healthcare surrogate designation can have one interested party as a witness, and someone else, the second witness, cannot be a spouse or a blood relative. So there are restrictions there. So for these documents, including a will, a living will, even a revocable trust does not need to be notarized, technically speaking. So will, living will, healthcare surrogate, revocable trust. For folks who still desire to get those documents but can't come to our office because we're at stay-at-home orders, you can still do it in a safe social distancing manner. What we have had people do over the past few weeks is, for example, we show them the document, we do the conference over Zoom like this, we prepare the documents to their specifications, we email it, they print it, and they may coordinate with two neighbors. And you can have, we call this, and it's BYOP, bring your own pen, right? So you have neighbors sitting outside of their doorway. They could be 15 feet away because they don't actually have to read the documents themselves. They just have to see you sign it, and they have to see each other witness it at the same time in their physical presence. And everyone has to be in the same physical presence. So to have people 15 feet away, the signer walks up, signs the document. They step back to 15 feet. Witness number 1 comes, signs, comes back. Witness number 2 comes, signs, and we can get valid documents signed that way. If you're not comfortable with that, then if you don't have access to witnesses, we have to wait until, unfortunately, July 1st, 2020, in order to have everything remotely witnessed and notarized. So if you do not have healthcare surrogate designations or wills done in advance of needing those documents, there is each document has its own statute that says then who is going to do what. As an example, for your will, if you are married and you have children of the same marriage, your spouse gets everything. If you are married but you have children who are from a different relationship, then your spouse gets half, and those kids also share in 1/2 of your estate, and it goes so on and so on. They give you all these different examples. Similarly, with a healthcare surrogate designation, you are subjecting yourself to the healthcare proxy statute, which means that's for someone who does not have a healthcare surrogate previously designated. And that is for, it says essentially it's the legal guardian first, then your spouse, then the kids who happen to be there, then siblings, and there's a whole order as well. So that is my time. We have so much to cover. We couldn't possibly get to all of it in the next 45 minutes or so. So that's why we're going to do more of these webinars. We can delve into these topics deeper. And if you want to submit your questions, we'll know how to tailor these presentations. So with that being said, we're now going to move on to Jarrett Williams. And before I introduce you, Jarrett, I'm going to make sure that I unmute